Hello, everybody. I made it a point to get some sleep today. I promise. Oh, yeah, I'm sorry about last night. I was so tired. I should have just gone to bed and not gone live, but I really wanted to hang out with my friends. Hello, Mortimer Duke. Not anymore. It's here. Hello, Nana Laura. Hello, C-Rex, my sweet sleepy mama. I hope you're having a wonderful time in Dreamland. Hello, Chinny. I'll get you again when you come back. Hello, Eileen E. Carlin. Yep, we have a bandit butt appearance. Hello, Charlie. How you doing, love? Hello, Tiana Miller. Good to see you, sweetie. Hello, Catherine Gaston. Yeah, he makes a regular fuss. Hello, Spider-Man, honey. Good to see you. So, we are going to have a Magistrate Norbeck kind of night. Yep, I loaded the whole week of Magistrate Norbeck in, and I edited stuff out that we've already seen, of course, and anything that wasn't interesting. And I was left with about an hour and a half of good stuff. Really, really good stuff. Because I am on that button with Magistrate Norbeck. He if there's something that has the potential of being streamed, he'll take it down right away. So I make sure I get him while he's live. Oh, there's a bandit. There's there's a Tiny Kitten Esquire. A Tiny Kitten Esquire appearance. Yes, Tiny Kitten. Tiny Kitten Esquire. And then, of course, there's an Ava appearance. Hi, Ava. Everybody's favorite. Did I say hi to you, Kova 42? Hello. We've got her Blue Buffalo Health Bar treats. She knows where the good stuff is. Peppercorn pistachios and Parmesan cashews. Well, I mean, you're getting your protein and your fiber. I can't knock it. It wouldn't be my first choice. But you know what? If I don't knock pork rinds, Pepsi, and ice cream, I'm sure not gonna knock that. Oh, guys, I love you all so much. What you doing, Bandit? You want to get some drink? You want to get some water? There you go, baby. Now you can go get water. For the person on the go. Tell you what, if I did pork rinds, Pepsi, and ice cream, I'd be on the go. I love you, Spider-Man. Oh my goodness. All right, guys, let's get into it.
All right, gentlemen, this is file 2500827SC, a small claims case, Taylor versus Duchett. We're here in small claims. What small claims means is that parties are trying to do this without any attorneys involved. Nobody is represented by a lawyer. And you're trying to do this right here in front of me, as opposed to asking for a jury trial or anything like that. I would be the one that makes a decision. So first things first, if you're both ready, willing, and able to proceed in front of me today, I'm going to swear you in. If you could raise your right hands. You swear or affirm that any testimony that you give here today would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Are we expecting any other witnesses?
No, sir. No, sir.
All right. So I did get a lot of information ahead of time on this. There were several police reports and investigations. So it's my understanding, essentially, Mr. Taylor bought a car from Mr. Duchett for $6,500, correct?
Yes. I bought it for $7,000 total.
Oh, it was $7,000. You're suing for $6,500. All right.
Yes.
So you bought the car for $7,000. And then just sort of immediately had problems with it. Well, let me start with you, Mr. Duchett. Mr. Duchett, do you believe that you owe any money to Mr. Taylor?
No, sir, I do not.
Okay. I am going to caution you for whatever you testify to here today, just because you are now under oath and this is being recorded. Most of the time, when we have a situation like this and Mr. Taylor were to go to the police and say, hey, I think I got ripped off, the police would say, well, you know, we understand what you're saying, but when we take this to a prosecutor's office, they're going to say, well, these cases are hard to prove. Maybe you should just sue them in civil court, which is exactly what they told Mr. Taylor to do and exactly what Mr. Taylor is doing.
Right.
I was a prosecutor for a very long time. This is not even a close call. You easily could have been prosecuted criminally for this. This is pretty much fraud. All right. So here's your problem, Mr. Duchett. First of all, this wasn't, you're not on the title to sell this car appropriately anyway. You know, you only have so long to switch the title from your name from the party you bought it from.
Right.
Right. You bought it from a different party for how much money?
$2,500.
Yeah. And then you turned around after a few weeks and sold it for $7,000.
Yes, sir.
Nice little profit for you, right?
Yes, Your Honor.
Quick profit in a quick amount of time. The problem is it was pretty clear to you when you bought it for $2,500 what was wrong with it.
Correct.
It was not only in the advertisement, but the person you bought it from was very clear to the police officers during their investigation that you were informed and aware that, you know, this engine probably had to be taken out and replaced, that it needed at least a new piston rod, right?
Right.
But none of that information was communicated to Mr. Taylor.
Correct.
All right. And then Mr. Taylor sort of, you know, immediately has a problem. Mr. Taylor, I see the receipts here that what it would have cost to get the Subaru sort of up and running. Was that an estimate you got, or you did in fact put the $8,172 into the Subaru and it is up and running?
Those were two estimates that I ended up getting. However, I have currently spent about $4,500 on parts so far, and that's not including any labor yet to be done.
Is it up and running?
No, sir.
Okay. So essentially, here's what we have to do, gentlemen. A 2013 Subaru Impreza with 141,000 miles on it is worth about $7,000. But this car is not worth $7,000. This car needs a new engine. I find that the seller knew that or was aware of that. Mr. Taylor was not aware of that. So what we have to do is come up with the fair amount of money that one of two things can happen. Either Mr. Taylor can say, I don't even want this car, or Mr. Taylor is saying, no, I'm going to keep the car, but I want a certain dollar amount to sort of make this be fair. All right. So essentially, sort of right off the top, Mr. Duchett, you have $2,500 into this car, right?
No,
That's what you paid for it.
that's what I paid for it. Yes.
Yeah. And so you made about $4,500 profit selling it to Mr. Taylor.
Aside from, I did actually attempt to fix the rod bearing myself, which when he test drove the car, it was all fine, but apparently it didn't last, or something else went wrong, or something like that.
So essentially, the problem is this car is worth something because it's not worth nothing. I mean, other than it needs a new engine. It seems to me, you know, body's in good shape. A lot of other things are in good shape. Yes, Mr. Taylor.
I believe he is mistaken because he would not let me test drive the car, and he drove it and was gentle on it when we went for a test drive.
Yeah, and that was my understanding, that essentially the test drive, you were present, but it was Mr. Duchett driving.
Correct.
Yes, sir.
All right. But essentially what we're saying here is the car is not worthless. So you would not get your, you know, the full price that you paid back. Essentially what I need to do is find what is fair. What is fair right off the top is Mr. Duchett, I don't think, should be making any profit off of this. Essentially what the car is worth and then what we should give back. So it's difficult to figure. Essentially what you guys need is a third party, me, to go, boom, here's what I'm deciding, all right? And then you have to make your decision of whether or not you can live with what I've done, or whether you're going to appeal this and say, no, I don't agree with what just happened there. I want to take this to general civil back in front of the district court judges. So essentially my ruling has two parts. One is we certainly don't want to have it that Mr. Duchett would profit from how this played out. I don't like the way this played out. I think this was deceptive at best. So we're talking about at least the $4,500. Now the reality is what is the car worth if you got to put the engine into it? And it looks like it would cost around what you paid for it to put the engine back in it. All right. So essentially what I'm not going to do is say that the defendant owes the plaintiff the entire value of you know what was paid for the car, because then essentially you'd be getting the car for free, but for you have to put an engine in it. So I think what I'm going to do in this is I'm going to list this at $5,500 in damages. All right. Now, damages and costs are two different things. So I want you to understand the damages is what I'm ordering Mr. Duchett to pay Mr. Taylor based upon what I think is the fair value of money that should go back to Mr. Taylor. I do think this car is worth something. It's just not worth the $7,000 you paid for it. And so essentially what I'm saying is it might be worth around $2,000, but there is a little bit of, let's call it,
a butthole tax.
Damages just because of how it went down. So I'm ordering $5,500 in damages. What I need you gentlemen to understand is Mr. Taylor had to pay certain monies out of pocket to get us here today. He had to pay a filing fee to court, and he had to pay to have you served. That was $144.30. You are able to recover those costs on top of whatever damages are assessed. So I just wanted Mr. Duchett to understand where that sort of extra money comes to, because the judgment here is going to be for $5,644.30. Now, here's what you gentlemen need to decide. Well, either one of you can say, I don't agree with what just happened there. I want to take this to district court and go in front of the district court judges. Mr. Taylor, because you were asking for more than that, you were asking for $6,500, you did not get that, and you could say, I don't think that's enough, I want more. Mr. Duchett, you could say, I think that's too much money to be awarded to the plaintiff, I think it should be less than that. Either one of you can appeal my decision, but to appeal my decision, you must do two things. One is you must ask for that within 7 days of today's date. Your window of opportunity to take this further closes. After that, this decision is the decision. And two, you must ask for that in writing. You cannot just call up the court and say, yeah, I want to appeal. So I'm going to ask you both, do you understand your rights on appeal?
Yes, sir.
All right. If you accept this finding, both parties don't appeal it, then we expect the parties to be in touch with each other to sort of work out how and when the judgment gets satisfied, i.e. money changes hands. But as far as what we do here in front of me right now, that we are all set for what we need to do today. I'm going to go ahead and release parties. Thank you.
I do have one question, Your Honor.
Well, he's not here anymore. Go ahead and ask your question, but if it's ex parte, meaning you're here, he wasn't here, I can't really answer it, but it might be a question I can't answer. Go ahead.
General question. I just need to know how I can transfer that money over to him legally. Like, is there a certain process I have to do, or is that just...
I will just say this, the court doesn't do the collection, so we do expect that the parties would be in touch with each other. So when you get a copy of this order, let's see here. I just want to see if on the, I mean, it should have everybody's at least address on the affidavit and claim. And so you'll get a judgment. And I want to see if it has phone numbers. It does. It has phone numbers on it. So when you get a copy of the judgment, you should have the contact information you would need. All right?
Okay.
Make sense?
I would just have to reach out to him, basically?
Yes.
Okay. Sounds good. Thank you.
All right, gentlemen, this is a citation that was issued on April 2nd of this year on Blue Star Highway there, City of Saugatuck. It's a speeding citation on an actual 55 and a 35. However, it was only written as 6 to 10 over. Mr. Crabtree, you are here on this citation to do one of three things. First is you could admit responsibility to the citation. Or two, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
I want to contest.
All right. Then even though I cannot see you, I'd ask that you raise your right hand. Same way the deputy is going to raise his right hand. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yes, sir.
I do. Yes, sir.
All right, Mr. Crabtree, it makes a lot more sense for me to start with deputy. He has the burden to establish to me why you were issued a citation in the first place. But then after that, you'll have an opportunity to either ask questions or testify on your own behalf. And with that, deputy, you want to pick up the narrative somewhere it makes sense, explain the issuing of this citation.
Yes, Your Honor. So when I issued the citation, I was, or I should say, before I issued the citation, I was running stationary speed enforcement near the intersection of Blue Star and Lake. I was facing southbound on the eastern side of the roadway of Blue Star Highway, just north of Lake Street. As I was doing so, I noticed the suspect's vehicle traveling northbound across the bridge that connects the cities of Saugatuck and Douglas. I noticed that this vehicle appeared to be traveling much faster than the posted speed limit of 35 miles per hour. I then activated my front-facing stationary radar device, which was reading solely the traffic that was coming at me and no other traffic. The defendant's vehicle was the only vehicle in this zone at this time. As I activated it, it showed me that the defendant's vehicle was traveling 55 miles per hour in the 35 Upon seeing this, I turned around my patrol vehicle and followed the defendant's vehicle until I was able to catch up with him on Old Allegan Road, just east of Blue Star Highway, so about a mile away. I explained to the defendant why I was stopping him. He did not agree with me. Eventually, him and I came to a bit of an agreement. We calmed down a little bit, and I only ended up writing him for 45 and a 35 as opposed to 55 and a 35. I should also note that my radar is calibrated at the beginning and end of every one of my shifts.
All right. Mr. Crabtree, what is it you'd like to tell me?
My wife is also here, Amber Crabtree. It's funny because I asked him if he had video because I had my cruise control on, and he also said that he couldn't see the proof of insurance. Well, I got enough of those tickets to know that that's automatically on your guy's computer. I just got tagged. I didn't even need to show my proof.
Sir, you don't have a ticket.
I don't know what the deal is.
You don't have a ticket for no proof of insurance, sir. I just need to know what speed you think you were traveling. I have testimony you were traveling 55 and a 35.
No, I wasn't. Me and my wife were just talking about my speed, and I was telling her I had it on cruise control. That's why when he walked up, I asked him if he had it on video. And then he said that he needed my insurance. I said, you got it on your computer. He said, no, I don't. So he lied to me.
Anything further you'd like to add, sir?
And my wife was right here as witness.
Yep, I was there, and he was not traveling that fast, sir.
All right. Anything further you'd like to say?
Nope. I've gotten tickets for speeding. If I was, I would have just pled guilty and paid it. But this time I wasn't.
All right. So, sir, the evidence I have before me is that the deputy has you going 55 in a posted 35 as evidenced by his testimony and his radar that he says was in proper working order that day. You just said, no, I wasn't. And your wife said, no, you weren't. I have no evidence on your side of you going how fast you think you were going. So I would have to decide that I find that you were, that there is enough evidence here to find you responsible on this citation.
That's unfair.
What's that?
That's not fair. That's very unfair. No,
sir,
I was not speeding.
I gave you an opportunity. You didn't even tell me what speed you were going. You just said you had your cruise control on. That doesn't help me at all.
40 miles an hour. I was going 40 miles an hour. That's the first time you just said that, sir, after proofs are closed. I'm sorry. I thought I said that.
No, sir.
I apologize.
And your wife didn't either.
I thought I said I was going for it.
I asked you and your wife multiple times if there was anything further you'd like to say as far as your testimony. You never provided an alternative to the deputy's testimony that you're going 55. So here's what I will tell you. Because you had an informal hearing, you do have a right to go to formal hearing. Formal hearing is in front of the district court judges with the prosecutor's office. I shouldn't give you legal advice, but you would need to testify to a speed less than what you're accused of going to have any chance of winning. But in order for you to go to formal hearing, you'd have to do two things. One is you'd have to ask to do that within 7 days of today's date. Your window of opportunity to continue to contest this ticket closes after 7 days. And two, you'd have to come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. Do you understand your rights on appeal?
I do. Now, why do I got to go pay if I'm innocent till proven guilty? I have the right to appeal.
Because, sir, at formal hearing, well, first of all, this is not a criminal matter, sir. It's not, we don't talk like innocent or guilty. It's a civil infraction. But in order, the formal hearing includes subpoenaing witnesses. The prosecutor has to be present. There's a certain cost to the court in order to hold a formal hearing. And for you to set up a formal hearing and then just not show up costs the court, like I said, an amount of money. So they make you post a bond to guarantee your appearance at formal hearing. The bond is the same amount as the fine. If you win at formal hearing, you get that money right back. It's only if you would continue to be found responsible, they would use that for fines and costs.
I would have taken responsibility if I had been speeding. I've had enough tickets, and I'm not, I'm just saying that. I know I have my cruise control on. I was just talking to my wife about my speed.
Even the cruise control that you told me is still speeding, right?
It's 40 miles
40
an hour.
and
I
a
was doing
35
5
is
over.
1 to 5 over.
And you're allowed to go 5 over.
Well, not if you get a ticket. My job is to decide if you were going a certain amount over the limit. If you were written for 5 over and you're going 5 over, you would be found responsible. I don't want you to think there's a certain
In
amount of
all
speeding you're
fairness,
allowed to
I've been
do.
told that it is legal to go 5 over. I mean, I can look that up. I
I don't know who told you that, sir, but I can guarantee you that's not correct. 1 mile over is still speeding if the officer were to decide to write you a ticket for that. But we're all set here. I'm going to release parties. Thank you.
It's called a speed limit, you know, limit meaning that's as fast as you can go. Yeah. Yeah. Let's see what the law library has to say about that.
Thank you, Your Honor.
Hello.
All right. On the Google Pixel 9, are you Miss Aguilar?
Yes, I am.
Okay. This is a citation. It was issued on April 4th of this year on US 131 there in Gunplain Township. This is a speeding citation on an actual 88 and a 70. However, it was only written as 6 to 10 over. So Ms. Aguilar, you are here on this 6 to 10 over speeder to do one of 3 things. First is you could admit responsibility to the citation. Or 2, admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened. Or 3, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
Number 2.
Okay, and what is it you'd like to tell me?
Your Honor, I'd like to explain what happened that day when I received the citation. I was in the left lane passing a slower moving vehicle, and I did increase my speed briefly in order to pass and merge back into the right lane. But I was not driving recklessly. I was pulled over shortly after by the officer who was originally traveling the opposite direction and made a U-turn on that highway. Given the circumstance and nearby traffic, I'm not even sure the speed he clocked was mine. I thought I was pulled over because at the time I did not have my license plate attached to the back. It was in my front seat. So I was not aware of getting pulled over for speed. I just thought it was my car needing the identification. During the stop, the officer did conduct the conduction or the interaction made me uncomfortable. He questioned several times about alcohol and drugs, despite there being no evidence. He kept pressuring that, so that kind of made me like really scared. But he did peer through my windows of the car. The car is brand new, so there's really nothing there. I've never been in trouble before. I have a really good driving record. I do take driving seriously. I lost my brother to a reckless driver. I'm just asking the court to just please take the circumstances into consideration when reviewing the citation.
Okay, well, ma'am, if you contested the citation, I would hear evidence and decide whether or not you were responsible or not. You're admitting responsibility to the citation, so I can't change the nature of your ticket. Now, lots of times what people, when they come in here, what they're concerned about is getting points on their license. Do you know what I mean by that?
Yes.
Is that what you're concerned about?
I'm concerned about the points and the amount. I'm just concerned about it all, Your Honor. Like, this is my first ticket I'm trying to fight.
Well, first of all, the officer didn't write you a ticket for going 88 and a 70. The trooper gave you a break and wrote you the second wimpiest ticket he could write you. I think this is only a 1-point ticket. But here's what I'll explain to you about points. I'm not going to give you points on this. The trooper didn't give you points on this. Points don't come from us. All right, that fines and costs is the only penalty. Now, points come from Secretary of State. Secretary of State court, 2 different animals. They can't tell me what to do. I can't tell them what to do.
Okay.
But here's what I would say about points. First of all, points die a natural death every 2 years. So if you could, if you want to, just outweight this point and it will go away after 2 years. But maybe more to the point, if this is what concerns you, is there's a way for you to get rid of that point. But all I can do is explain to you how to do it for yourself. I can't do it for you. But are you curious?
I am curious. I'm also curious to know if I don't know, like I'm trying, this is my first time. I'm not sure if I'm doing this right. Trying to fight it. I'm just agreeing with the officer. I honestly don't even remember that day how much speed I went, because like I said, he was traveling opposite and there was multiple cars and he was behind another car.
Here's a couple of things I would tell you. First of all, we do not mind people coming in here and you know, essentially saying, look, I don't know what I'm doing, but I want to see what happens, and you know, this is what I want. The first thing first is, you know, when you're telling me that I thought I got pulled over for no plate, that doesn't make a lot of sense, because the trooper, if he's coming at you the opposite way, he wouldn't know you didn't have a plate on the back of your car. So to spin around on you and pull you over is probably for a moving violation. Well, the other thing is, what's that?
I am so sorry, Your Honor. You can finish. I'm so sorry. I didn't mean to cut you off.
The other thing is, most of the people don't realize just how far away that they're getting radared by that. So in other words, it would be the opposite direction radar in the front of the trooper's vehicle. Yes, you likely got radared when you were passing someone, and that's why it was 88. I will tell you this, though. The actual law is you still can only go up to the speed limit to pass somebody. That's how slow somebody's supposed to be going for you to pass them. You were allowed to go up to 70 to pass, but passing is not an exception to the speeding rule. You still only can go the speed limit. But like I said, if you don't remember how fast you're going, the trooper's testimony would have been, of course, that his radar said 88, and then he checked his radar. So if you had had a hearing, I likely would have found you responsible. But here we are, sort of on the back end. But here's what I can tell you about points. On the Secretary of State's website, they have something called the Basic Driver Improvement Course. It's a safe driving quiz that you take online. I can't imagine it's very hard. It just takes up some of your day. Here are the 3 rules for it. You can't be a CDL driver, right? That means driving the big rigs. You're not driving the big rigs, right? 2, you can't be carrying more than 2 points on your license already. You wouldn't be, because you said I got this good driving record before this. And 3, you can't have taken this test before to get rid of points, which I don't imagine you have before. You don't get to keep using this trick, but if you go to the Secretary of State's website and you take that Basic Driver Improvement Course, the carrot they give you is they'll remove the points from any one moving violation, which is what this is. So you have the opportunity to make it 0 points, but you have to jump through those hoops yourself. I can't do it for you. Does that make sense?
That does make sense.
So otherwise, all that's left for you to do is, for us here on this ticket, is to call the district court to make arrangements to pay that fines and costs. And the point will either go away after 2 years, or you can make it go away if you want to take those steps. All right?
All right. I do have a question. If we're able to pull the footage of that day, because the officer did say his camera was on. And when I was passing the car, he wasn't behind me like right away. It was a few miles down the road, and then he went behind me. So that's why I thought it was my license, not the
I will let the trooper correct me, but when they say that, the camera comes on when they turn on lights and sirens. So it wouldn't have been on coming at you when it caught you speeding, and then he looped around on you, and then if to pull you over, he put his lights on. That's the camera footage he'd have, not of the speeding incident.
Can he pull that's so difficult. That's since there is no proof, and he said I was going 88 and I'm just agreeing to it. What do I do, Your Honor?
Well, you could fight the ticket, but like I said, I know what his testimony is going to be, and your testimony is going to be, I really don't know how fast I was going. So
but
there's not much.
You just said he didn't have. You just said that there was the radar he can't prove that radar was my car when he was trying. No,
ma'am, that's sort of a misunderstanding. Proof comes in many different forms, right? Now, if he had video footage, right, that would be one type of proof. But his testimony is in fact proof, because he would be under oath and he would testify as to your speed. That is proof.
And for mine, can I be under oath and testify?
You would be under oath as well, but your proof would be, I really don't know how fast I was going. I just don't think I was going that fast. Which one of those two proofs sounds more firm and that I would go with at the end of the day?
Well, I would go with mine because the officer was really traveling the opposite direction. And I know I'm a safe driver. That's why I said I don't know. And that's why I was so confused when he pulled me over, was because
Ma'am, would you like to have a hearing?
If that's possible, yeah, I think I would.
All right. So, Trooper, if you would go ahead and raise your right hand.
Yes, sir.
Ms. Aguilar, go ahead and raise your right hand.
I apologize about the video as well. I'm having connectivity issues.
That's all right, as long as I can hear you. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Yeah.
All right. Ms. Aguilar, it makes a lot more sense for me to start with the trooper. He has the burden to establish to me why you were issued a citation in the first place. But after that, you'll have an opportunity to either ask questions or testify on your own behalf, all right?
Okay.
And with that, Trooper, if you want to pick up the narrative somewhere where it makes sense, explain the issuing of this citation.
Yes, sir. I'd like the court to know, to start off, that I'm a certified MCOLS radar operator. The unit that I was using on the day that I issued the citation is certified by the state of Michigan radar unit. The radar unit that I was using is affixed to my patrol car dash. And I verified the working condition of the radar at the beginning and end of my shift, as I do every single day. On this specific day, on April 4th of 2025, approximately 7:49 a.m., in the county of Allegan, township of Gunplain, I was actually working stationary radar patrol in the median just north of 106th Ave. I was facing oncoming traffic, so southbound traffic, while my patrol car was facing northbound. While doing so, I activated my stationary radar, opposite direction radar, at which time I observed a white Nissan passenger car pass through the operational range or beam of my radar. At this time, I observed the vehicle traveling 88 miles an hour in a 70-mile-per-hour zone, and subsequently initiated a traffic stop of the vehicle and identified the driver as Miss Aguilar. And after a brief investigation, issued a citation for 6 to 10 over rather than the 18 over that I observed her traveling. I would like the court to know that my radar unit was free of any obstructions. The vehicle that I was tracking was the vehicle being driven by Miss Aguilar. I know that because as the vehicle passed through the operational range of my radar, I heard an audible tone corresponding with the speed. And then once the vehicle passed through the operational range of my radar, the tone ceased to exist. So I'm confident the target vehicle was the vehicle that I stopped. And the driver of the vehicle was the driver that I issued the citation to.
And Trooper, I'm just going to ask you a question or two because I know that Miss Aguilar is interested in how this works. You testified that you checked your radar at the beginning and end of your shift. I'm assuming what you mean by that is you checked it against your separately calibrated speedometer.
Correct. So we're required at the beginning and end of every shift. It's actually on our program or on our daily system where we check and track the condition of the radar to make sure it's working in proper condition, that everything is accurate, and that there is nothing is inaccurate, nor is it not functioning properly.
And then let me ask you, Trooper, if during the check at the beginning of your shift, it did not check out, what would you do?
I would not be able to conduct radar. I would have to immediately contact Wheels or our technicians to come immediately and fix and calibrate and make sure to get the radar in working condition. It's actually, we are not allowed to use that radar unit if at any point in time it is not in proper working condition.
And then if it was working at beginning of shift, you wrote tickets all day, and then at your end of shift, there was a problem with the radar. What would you do with the tickets you wrote all day?
They would immediately have to be voided.
All right. And so, Ms. Aguilar, I'll turn this over to you now. So it's your turn to either testify on your own behalf or ask questions of the trooper.
I I would like to get proof. I feel like I should see the video to testify for the proof.
Ma'am,
To see
the enormous amount of evidence that he just testified to is the proof, just so we're clear.
Yeah, he said that he was clocking south, but I saw him while traveling before passing. He was moving and making a U-turn. He wasn't sitting still. He wasn't. That's why I'm really confident that there was other passing vehicles. And he said that he's confident that the radar did read, and that's not technically proof. Like he's just verbally saying confident. And then he was behind a different car before.
No, ma'am. I'm gonna sort of crawl through this because if there was somebody else behind you, we wouldn't do this. But I want you to leave here understanding what happened.
Okay.
So what he testified to is he's literally just sitting there with his radar on, right? So to make sure that the radar works correctly, in the beginning of his shift, his radar has to check against a separately calibrated speedometer in his vehicle and come up with the same reading. If it doesn't, he can't use the radar all day. Then he uses the radar all day, and he does that check at the end of the shift too. And if it's not working at the end of the shift against his separately calibrated speedometer, he would just void all the tickets that he wrote.
Right.
So the first thing he said is visually he sees your car, right? Now we would let back in the old days, you'd let officers or troopers guess at speeds because this is what they do all day and they're pretty good at guessing speed. But we don't let them say how fast you're going. But we do let them testify that they think this automobile is traveling above the speed limit of 70 miles an hour, which he did. Okay. Then what he did is get you with his radar, right? So he knows that you're the car in the radar because it tones out. In other words, it makes an audible tone. And the audible tone changes in pitch depending on how fast it goes. So he also knows if that tone doesn't match the number he's seeing, something's wrong. Okay. And then once your car is out of the cone of his radar, the tone stops. So that's how he knows it's sort of your car.
And that, my friends, is the part that she is missing. She's not realizing that the officer clocked her from a stationary position and she passed his vehicle. And then he had to, do the U-turn, as she called it, and come catch up to her. Because she's convinced that the officer was traveling behind her when he ran the radar. And that's just not the case.
Then he sort of flipped around on you and pulled you over. So he actually has testified 3 different ways that you are traveling well above the speed limit of 70. And what you're telling me is, I don't know how fast I'm going, but I just don't think I was going that fast. Now I have to pick one of those sets of evidence, right? Either your evidence, which is your testimony, or his evidence, which is his testimony. And I don't have to find beyond a reasonable doubt. You've heard that before, right? Because this isn't a crime. The standard for this, because it's a civil infraction, is you likely did it, 51%. So when I weigh all his evidence and testimony versus essentially the lack of evidence and testimony on your behalf, of course I would find it is more likely than not that you were actually speeding. You were actually going faster than the ticket you were written, but you were at least going 6 to 10 over. And that's why I would find you responsible. If you're searching for more than that, or that doesn't feel like a sufficient explanation to you, I don't know what else I can do for you, ma'am. That's how this works all day, every day.
I understand, Your Honor. Is it possible confirmation from his radar to make sure that it was working accurately that day for me?
Well, I could have him testify to that, but we're going to wrap things up here. Every, I think, 90 days or so, a tier 3 operator checks the radars, and then every 120 days, a tier 4 operator checks all the radars of the car. And if there's any problem with any of the radars, they take those out of order. And there is some sort of maintenance logbook that the state police keep for that. You probably could subpoena those records or ask at a formal hearing that somebody would bring those records in. But at informal hearing, I would not expect the trooper to be familiar with those records at this state and time. Just know that there is, in fact, a method of continuously checking these radars that if there are problems, they're taken out of circulation so that they're in circulation is sort of the prima facie evidence that against that set of checks, they are working.
Thank you, Your Honor. I just want you to
sense?
that I wasn't driving recklessly. I was just passing. I do apologize.
Ma'am, reckless driving is actually a crime. There is a whole charge for reckless driving. That's not what you have. You just have a charge of speeding, like lots of people do.
Take into consideration if the ticket can be waived because I am a responsible, good driver.
And ma'am, here's the problem, right? If what we did was judge everybody who gets a ticket on whether or not they're a good driver or not, that would be incredibly unfair. So bad drivers are just automatically responsible for their tickets because they did it in the past, or good drivers couldn't possibly be speeding because they've never got a speeding ticket before. That's sort of not, I mean, it's scary that that would be how the legal system works, right? I would judge this circumstance just on this circumstance, this time frame, and the facts that are presented before me, which is exactly what we did. Now, as far as getting a break, you did get a break. You got a break on the side of the road where this trooper decided to write you a ticket that's a third less than what he could have written you for, right?
What could he have written me? I don't know what he could have written me for because.
Well, ma'am, if you're going 88 in a 70, how many miles over the speed limit is that? 18 miles, right?
Well, that's what he's saying, and I was agreeing. So obviously, I have to own up to that.
No,
so,
ma'am.
yeah.
Even if you we stopped doing that. I didn't take it that you agreed. We had a hearing, and I found clearly that you were going 18 miles over the speed limit. He did not write you a ticket for that because that's a 15 to 20 over. That's not what you're here on. That's not what I just found you guilty on. I found you guilty on a 6 to 10. He could have written you a 10 to 15, and you would have been responsible on that. He could have wrote you a 6 to 10. He could have wrote you a 1 to 5. He not only gave you a break 1 down, he gave you a break 2 tickets down. And you're still here just saying nobody gave you a break, right?
No, you're misunderstanding me because I'm not aware of breaks and tickets. This is my first one. So I hope you understand that I don't know that that is a break. But thank you for informing me about that. I'm here to fight it because I was just speeding to pass a car. That's it. That's all, Your Honor. And that's the break that I was looking to get. If I'm accused of speeding, I apologize. I was just passing a car in the left lane and got back over. He then was traveling behind a different car, turned his lights on, then came to me, and then I pulled over. Like I said,
it takes a while for him to catch up to you, right? Because you're going.
He didn't take a while.
70-something miles an hour, and he's going no miles an hour. He has to turn around and come after you. Takes a while. But one more thing, Miss Aguilar, because you had a contested hearing, you now do have a right to go to what's called formal hearing. Formal hearing is in front of the district court judges with the prosecutor's office. But to go to formal hearing, you must do 2 things. One is you must ask for that within 7 days of today's date. Your window of opportunity to contest this further closes after 7 days. And 2, you must come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. Do you understand your rights on appeal?
Yes, I do.
All right, then we're all set for what we need to do here today. I'm going to go ahead and release parties. Thank you.
I would not be so sure that she understands her rights on appeal. Maybe she's just agreeing that she understands her rights on appeal. Oh my God, I just can't with that woman.
Thank you, sir. Have a good day.
You too.
Don't touch anything. I said it'll go away.
All right, jailer, your name, please.
Hello,
What's your name?
Ashley Cook.
All right. Ms. Cook, I have a couple of different files here. They all seem to be misdemeanor files at this time. One new one here looks like 244396ST. I'm going to go ahead and read that to you.
Mariah Silverstein appearing on behalf of Ms. Cook for the limited purpose of arraignment. We reviewed the charge and waive a formal reading. She'll enter a plea of not guilty and qualifies for a court-appointed attorney.
All right, so ma'am, you will have the public defender as your attorney for the remainder of this case. So ma'am, you know that you have some other cases coming down the pike. They're not up to date. They're not misdemeanors. Do you want a PR bond on this and then you won't get credit for time served on these 3 files that you're already out on bond for? Or would you like them to be low cash sureties so that you will be getting credit on them while you're sitting?
I don't know what that means, sir.
Okay, so right now you have 3 files in front of me, right? 2 of them, you're
Yes.
already out on PR bonds, right? Oh, no, actually, it's cash surety bonds you haven't posted. Well, that's
What is
fine,
that?
then we'll just leave them as cash surety bonds, so.
So that means does that mean I don't get out?
Correct, ma'am. And I think you know you got picked up on some new cases, right? That aren't these little misdemeanors. I think I just charged it today. Saw a warrant come through for Ashley Cook.
For
You have
what?
no idea what I'm talking about?
Yesterday I had an officer. He went through my stuff and let a guy.
I don't want you going
Take all
into
my
any
stuff.
additional details.
So what I'm saying is, you're not
That's all
getting
I
out
know.
of jail. I think I just gave you a several $1,000 bond on a felony case. It's not gonna be up till tomorrow. But we'll set this at $300 cash surety. That's,
What is
no
that?
driving without a valid driver's license. And then you're already incarcerated on the 2 other matters anyway. The larceny is set at 500 cash surety, the trespass at 100 cash surety, so we don't need to review those.
But the trespassing, sir, is my kid's
You'll
dad,
get
and he
a
said
next court date in
dropping
courtroom
that.
B in front of Judge Belargin. That'll be the next time you're doing court, at least on that misdemeanor, the new misdemeanor that we just went over today.
What? When?
If you're still incarcerated, corrections will make you available.
Okay, you're done, Christine.
I didn't
Yes, ma'am.
understand.
Your
how-
life gets confusing when you pick up multiple crimes and miss court dates. You have 3 open misdemeanors. You have some new felonies coming. You're not done on any of them yet because you don't show up for court. Now you're sitting in jail on 3 cases. You'll have some more tomorrow. If you can't make bond, you'll sit in jail, but corrections will make sure you get to your court dates this time. You're all set.
I'm sorry, sir. I failed. But you could be kind. Kindness is key.
Okay. Good afternoon, ma'am. Your name?
Christina Riddle. Hello, sir.
Okay. Ms. Riddle, I'm not sure which ones are new or not. You have file 2508669 ST, 2508667 ST.
Why would I not?
You're picked up on a warrant because you missed your court dates on these, right? You've already been arraigned.
I was only
Correct,
provided
sir.
with the ticket from March 23rd, 2025.
Which one?
March 23rd, 2025.
Yeah, that's not, I don't even have either one of those in front of me. I have them from February 5th and February 11th.
Okay, then I would ask for a formal reading at this time.
Okay. Well, no, those are old ones.
Oh,
And then
okay.
you're right, here's the new one. From 323, you said?
Yes.
Yeah, the problem is Miss Riddle just keeps on driving, and then when we tell her she has to come in for arraignment in person, she skips the court date. So she has several different bench warrants out for her. But you're right, this new case, she hasn't been arraigned on. It's again for traffic violations from March 23rd of this year. But you had a chance to review that with her?
Yes, Your Honor, and we waive a formal reading of that case. She enters a plea of not guilty and qualifies for a court-appointed attorney.
These two are identical. So the good news is, ma'am, you will have the court-appointed attorney representing you on these matters for the duration of them. Your bond on your open cases is $2,500 on each of the previous driving without licenses that happened in February. You'll now get a next court date in courtroom A on those. This one would just set the bond at $500 cash surety. But again, that's no driving without a valid driver's license. You will get a next court date. They'll all be up together. That's the good news. In courtroom A in front of Judge Scotchless. You will get copies of those dates and times. You must show up for those dates and times. If you're not going to make bond, then corrections will make you available for your court dates. You're all set.
Thank you, sir. I should stuck on.
Your Honor, Snyder bonded.
Okay,
Thank you.
we are all set. That means they must have paid their whole.
Hearing on behalf of Mr. Burrus for the limited purposes of arraignment. I did review the felony complaint with Mr. Burrus. We would waive formal reading of that, ask the court to enter a not guilty plea on his behalf, and have this set for probable cause conference and preliminary examination. I did screen Mr. Burrus for court-appointed counsel. He did qualify, and that form will be submitted to the court. An additional, I realize that Mr. Burrus is a fourth habitual offender, but we would ask the court to consider a personal recognizance bond, given the fact that he's indicated to me he has not been in trouble in quite some time. The noted convictions for the habitual fourth offense are quite old, and he is disabled, and being in jail will be a hardship for him.
And I'm a senior.
So, Mr. Burrus, I hear everything your attorney's saying on your behalf, but the problem with what she's saying is when you got pulled over, you already had a warrant out for Kalamazoo, so you at least have one other matter, right?
No, sir, I'm all cleared away, sir.
Well, I'll reduce it to $1,000 cash surety, but on a life offense, you wouldn't get a PR bond. That is no drugs, no alcohol, no marijuana. You already have next court dates. May 8th is your probable cause conference. May 13th, your preliminary hearing. That's in courtroom B in front of Judge Belargin. You will get copies of those dates and times. You must show up for those dates and times. You're all set today.
So you're saying that I have how much of a bond, sir?
$1,000 cash surety.
I won't be able to, is there any way you can,
Sir, you're
well,
facing
sir, I don't
life
have-
imprisonment
I'm
as
saying
a
this,
habitual
citizen, sir.
offender fourth. You're arrested because you already had other warrants out. You are not PR bond material.
so I'll just sit and wait then.
Yes, sir, apparently.
Bonds can be readdressed at your probable cause conference, okay?
Yes, sir, because like I was telling Your Honor.
No,
Your
I
Honor,
don't
I'm-
want you to talk about
See-
your case or anything like that, okay, Mr. Burrus? I just wanted you to know
yes.
that you can readdress it next week, okay?
He did not look that old. Like facially, he didn't look that old. His voice sounded old, but he really did not look that old.
Good afternoon, ma'am. Your name?
McKenzie.
Okay. Looks like we have two files here, one on misdemeanor and one felony. We'll start with felony. 250192FT. I'm going to read it to you.
Thank you, Your Honor. I did have a chance to meet with Ms. McKenzie before coming on the record today. Carrie DeVille appearing on behalf of her for limited purposes of arraignment. We did review the felony complaint, would waive formal reading of that, ask the court to enter a not guilty plea on her behalf, and have this set for probable cause conference and preliminary examination. I did screen her for court-appointed counsel. She did qualify, and that form will be submitted to the court. Did you want me to review the misdemeanor file as well?
Sure.
All right. We did also discuss that file and would waive a reading of that, ask the court to enter a not guilty plea and have it set for a pretrial conference. Again, she will have a court-appointed counsel in that file as well. I don't believe she's set for a PR bond at this time. We would ask the court to consider a personal recognizance bond on her behalf. My client vehemently denies many of the allegations in the felony complaint. She did just recently have an infant. She's got a 1-month-old and she has 3 other children that she's responsible for, and is a member of the community and would be able to make it to court.
Okay, so ma'am, you would not get a PR bond because you have 2 different matters here, both accusing you of the same thing, retail fraud. The felony file is industrial strength retail fraud, and it was your fleeing and eluding was up to 120 miles an hour. So it's not really a PR bond situation.
I have a question.
Yes.
Well, it's not really a question, but I was never driving, and I don't know why I was being charged. I don't know why I'm being charged with fleeing when I was never the driver.
Well, ma'am, that's a question for your attorney. They'll be able to explain it to you how that is a possibility. I will reduce this to $2,000 cash or surety. Now, on your misdemeanor case, so you have the public defender on both matters. On the misdemeanor case, I'd give you a choice. You normally would get a PR bond on that, right? And if I'll give you a PR bond if you want, then you would only have to make bond on the felony matter. But if you think you're going to sit in jail on the felony matter anyway, then instead of a PR bond, you may want a low cash surety on the misdemeanor so that you're getting time served on that case as well while you're sitting in jail anyway. I'd do it either way, whichever way you want. You want to leave it as a PR bond on the misdemeanor or change it to a low cash surety? Okay, so we'll just leave it as a PR bond for now. You're going to get different court dates on the misdemeanor. That's in front of Judge Scotchless in courtroom A. On the felony, you already have next dates. May 8 is your probable cause conference date, and then you have a preliminary hearing set on May 14th. That's all courtroom A in front of Judge Scotchless. You will get copies of those dates and times. You must show up for those dates and times. If you're still incarcerated, corrections will make you available, but you are all set at this time.
Having that attitude about you like that just cost you any jail credit.
Your Honor, did the retail fraud misdemeanor, did that go to a cash surety?
No, I just left it at $500 PR bond. I didn't.
Thank you.
Good afternoon. Your name?
Russell Schuman.
Okay, Mr. Schuman, this is, well, it looks like you got 2 different files here. The extradition file and then a felony matter 251490 FB. I'm going to read that one to you. We'll start with that one.
Thank you, Your Honor. Carrie Dibble appearing on behalf of Mr. Schuman for the limited purposes of arraignment. We did review the felony complaint together. We would waive a formal reading of that, ask the court to enter a not guilty plea on his behalf and have the set for probable cause conference and preliminary examination. Mr. Schuman has indicated to me that he will be hiring counsel. We will note that on our court-appointed form and submit that to the court.
Okay. So, sir, you're going to retain your own attorney, is that correct?
Yes, sir.
On this matter. Looks like you're out, you actually posted the $5,000 cash or surety bond, right?
Yes, sir, I did.
All right. So on the actual OWI, that is no drugs, no alcohol, no marijuana, no driving without a valid driver's license, and that you already have next court dates. May 8 is a probable cause conference. May 14th is a preliminary hearing. That's in courtroom A in front of Judge Scotchless. You will get copies of those dates and times. You must show up for those dates and times, but you are not incarcerated on that particular matter. The other case, however, the extradition matter, that does in fact have a bond on it. Did you waive reading, Ms. Dibble? Is he also gonna, are you gonna retain your own counsel on the fugitive matter as well?
Yes, I'm going to try to post the bond on that today.
Okay.
I'm a business owner. I have 11 employees. I own my own home, everything. And I have to get out to be able to take care of all of this so I can deal with these charges without losing my business and putting 11 people out of work.
He's far too important to face the consequences, Your Honor.
Okay, but you do have a $50,000 cash bond on the fugitive.
Yeah, is there any way we can reduce that at all?
Well, here's the problem, sir. So you're on probation out of Georgia, meaning I know you're not supposed to pick up OWI third offenses while you're on probation. So you have a probation violation there, as well as a new felony here. The fact that you're no longer in Georgia and you're in Michigan is exactly why the fugitive bonds are set so high. So I wouldn't adjust that from the 50,000 at this time. You would be able to waive extradition, which it's my understanding you don't wish to waive extradition.
Is this cash or surety, the bond?
Yes. Okay. So you need to put 5,000 up in cash and the rest in collateral.
Yes, sir.
All right. So this will get a next court date in courtroom A to see if there's been any progress with the governor's warrant from out of state. But you can also address bond every time you're up in front of the judge, especially when the prosecutor's office is also there. They may agree to a reduction, but I wouldn't agree to a reduction at this point. That makes sense.
Yes, I understand. I'm pretty sure that if I bond out, that I can handle this Georgia over the telephone. This is a matter from 16 years ago that 14 years ago I did take care of, paid all of my fines, everything. So I don't even understand why this is happening right now. Like, it's from 16 years.
I don't either. The only information the court would have is what your attorney reviewed with you, that they say there's a probation violation out of Georgia.
Yes. Yeah.
All right. Okay. You're all set then.
Okay. Thank you.
Because you do not wish to waive, right?
No, not at this moment, because I would lose my business if I can't find out the handle this. Okay. Thank you so much. When would be the extradition hearing, you said?
They'll set that for a date in front of Judge Scotches. I don't have dates right now.
It'll only be a later date. Okay. Thank you so much.
Okay. Good afternoon. Your name?
Andrew Vantel.
How about Stevenson?
That was my old last name.
Okay. This is a felony file 213268FY. I'm going to read it to you.
Good afternoon. Assistant Public Defender Darius here, appearing on behalf of Mr. Vantel for the limited purpose of arraignment. We have reviewed that file with waiver reading. He's asking that set for probable cause and prelim. He was screened for court-appointed attorney, and that has been granted.
Okay. So, sir, you will have the public defender as your attorney for the remainder of this case. This is a failure to pay child support, so your bond is the amount of arrearage. That is $94,165. It is a cash-only bond.
$94,000? Show of hands. Who thinks he's making bond? No one? No one? Yeah, and who thinks he changed his last name, sort of, to get out of $94,000 in child support?
Already have next court dates on May 8th. That is your probable cause conference. Your preliminary hearing is May 13th. That's in courtroom B in front of Judge Belargin. You will get copies of those dates and times. You must show up for those dates and times. If you're still incarcerated, corrections will make you available. You are all set.
Thank you.
Hello.
All right, gentlemen, this is a citation. It was issued on March 21st of this year on Culver Street there in the city of Saugatuck. It's for a disobeying traffic control device. You are here on this citation, Mr. Licata, to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened. Or three, you wish to contest this citation, in other words, fight the ticket at what we call informal hearing. What were you looking to do?
I'm sorry, is this the judge talking to me?
Yes.
Thank you, Your Honor. My apologies. I'm in the conference room on a phone, so I can't see who's chatting. I don't want to admit guilt, but I would like to explain some kind of explanation to why this might have occurred.
All right. What is it you
Is
wish
that
to
fine
do?
with you? Sorry. I have in the past, recently, back in January 19th, had an accident at the roundabout, and I called the police right away, had a ticket for too fast for conditions, paid it, no questions asked. But with this ticket, it's saying that I ran the stop sign down there, disobeying traffic control device. I felt that it could have been something that could have been explained to me or chatted about, but I was given a ticket instead. I'm looking for maybe forgiveness on it, or to be able to show through my driving record that this is something that isn't a normal occurrence. I want to find some kind of sorry, trying my hardest to do the vocabulary with you.
I understand, but here's the problem. I can't negotiate a ticket with you. This is a separation of powers issue. I'm judicial branch. So I can decide whether or not you should be found responsible or not responsible on the ticket you're written. Whether or not to write you a ticket, we're already past that. You weren't given a warning, you were given a citation. And what the citation is up to the executive branch, i.e. the deputy. So all I could do is you could have a hearing and I could find that you did come to a complete stop at the stop sign and therefore shouldn't have got this citation. Or I would listen to the evidence and testimony and find you did not come to a complete stop and find you responsible on this citation.
Yes,
but
sir.
The time and place for negotiating the ticket away is already passed.
I guess just to educate myself, when would be the best time to do that? Because when I ever ask an officer about it, they tell me I've already had the ticket written. I have to come to court now. So this seems like this is the next step after a ticket being written.
It is. The time to get a warning is on the side of the road. You were issued a citation, so you are past the warning phase.
Yes, sir. Sorry.
And just to let you know, I would never make my decision on a ticket based upon your driving record. That would be unfair of me to say, oh, he gets tickets all the time, so he must have blown the stop sign. Or to say he never gets tickets, so he probably did come to a stop. That wouldn't even come into play.
Yes, sir. Besides my word against Mr. Kaminsky's word, I don't have any evidence. I wasn't able to pull any kind of cameras from the area, and it would just be my word against an officer's word.
All right. So do you wish to admit responsibility, or do you wish to have a hearing?
How much? I guess my question is then next, just to ask, and I'm sorry if this is using your valuable time.
I do not mind you asking questions. I want you to. I want you to leave here understanding everything that happened. So go ahead.
So from the officers, when I first got the citation, it went from him coming up to the car, going back to his car, and then writing me a ticket and explaining why I had the ticket. When I went to negotiate then, at that point, the ticket was already written and there was nothing I could do. What would I do in the future then? Would I try to understand the, sorry, I was a little confused by that. Before the citation's written, then try to talk to the officer about it? Would that be your best advice on that?
Well, I wouldn't give you legal advice. It would be inappropriate for me to do that. But the officers have their discretion to write you a citation or to not write you a citation. I can't tell you what his opinion was. It was probably based upon his assessment of the egregiousness of the failure to stop.
My second question is then, I usually just pay my tickets because usually officers have a reason, but I cannot afford to get any points or to pay a ticket at this point because I live in my car and the insurance will go up.
Here's what I can explain to you about that, sir.
Yes, sir.
First of all, the fines and costs are statutory. So that's not me picking a number out of the air. Everyone pays the same amount for the type of ticket they get. Now,
Yes,
points, lots of people are concerned about points when they come here. I will tell you this, I'm not going to give you any points on this citation. The deputy's not going to give you any points on this citation. Points don't come from us. The court, the only punishment the court has for a citation of this nature is the fines and costs. Now, the Secretary of State of Michigan, that's who gives you points. Secretary of State and court, two different animals. They can't tell me what to do. I can't tell them what to do. I can give you the talk, and I will give you the talk since it seems like it concerns you about points. Here is what I would tell people about points. First of all, they die a natural death every 2 years. They just kind of go away again. So you can always outweight them. But more to the point, especially maybe more to your point, there is a method for you to make your points go away. I can't do it for you. All I can do is explain to you how to do it for yourself. You're interested in learning that?
If I may, if I understand correctly, in the state of Michigan, you only get one of those to remove points in your driving record time, and I used that when I was 18 for a rolling stop sign as well. Instead of fighting it, I just wanted to pay you guys so you guys didn't get upset with me wasting anyone's time and just paying my dues.
I do not know how long in between. I don't think it's once in your lifetime. I do think you can't keep doing this over and over again, but I don't know what the time limit is. When you say 18, how old are you now?
I am 24.
So 6 years? I mean, you'd have to check with Secretary of State about whether they'd let you take that basic driver improvement course over again to get rid of points or not.
From what I understand and have read, that you only get one of those. And then on the points, my last ticket I had during the ice storm, I slid through the roundabout and I got a violation for too fast for conditions when I was only going 5. That's its own thing. But I ate those points in that ticket.
Let me explain that to you as well, since that is not a speeding citation. You can get that ticket going 5 miles an hour. What you have is a duty to maintain your car on the roadway. So anytime you slide through or slide off, that's the ticket you get. It's not really saying that you're speeding. It's just saying perhaps if you were going slower, it wouldn't have happened.
I still received, I think it was 3 or 4 points from that. From the second.
That would only be 2 points.
Then you seem more educated than I am on it.
Yeah,
all I've done is Google. Sorry, Your Honor.
So you would have got 2 points for that one, and that one will go away 2 years from whenever it happened.
I guess I'm looking for. So if I'm understanding correctly, you can't forgive this ticket or get rid of this ticket unless I want to go to the next step of fighting the ticket. And then I'm guessing that Mr. Kaminsky is here then as well?
Correct.
Correct. And then Kaminsky is still saying that I did run the stop sign?
I don't know what he would testify to, but he's here on a citation that he wrote. So I'm assuming, yes, he would testify that he watched you come, roll through a stop sign.
Okay. I don't want to admit guilt because I can't either afford nor give up the. I need to keep my vehicle and be able to stay and live in it and afford the insurance on it.
Okay.
So I
what do you want to
guess
do?
my choice would be, it's on the back of my thing. Admit responsibility with. What does admitting responsibility with explanation do for me? If you can't forgive a ticket.
It allows you to explain why it happened, and so that we don't think you did it because you don't believe in stop signs or you're a bad driver. I don't know, whatever your explanation is of why you didn't stop at the stop sign, you would give that explanation to me. I wouldn't give it to you.
And then my question then at that point, again, I'm sorry, I hope I'm not wasting your time at all, Your Honor.
There's nobody after you, so you're good.
Thank you, sir. I appreciate that. So if I was to admit with an explanation, what does that leave you options of thank you for your explanation, here's your ticket to pay for, and then from there on, because you can't
Correct.
forgive me with my ticket?
Correct.
So it's basically admitting responsibility, taking the ticket, giving you an explanation, which doesn't really do me any good at all, because I will just
Yes,
be
it does.
still.
You sort of presented that this is, the points are going to be more of the issue to you. You're living in your car. I will make this be a $55 fine instead of $110 if you're just going to admit responsibility, save you some money. I can do that.
I can do can I ask them, is there a, and I appreciate that a lot, Your Honor, with the going to 55, does that change what's the term for it? Change what the ordinance would be?
No, it's just the fine. So in other words, this is a $110 ticket, but I can reduce the fine. And so what I'll do is reduce the dollar amount you owe on the very same ticket.
Okay.
As a consideration to you because of your circumstances.
No, I really appreciate that, honor, Your Honor. I guess I can, can I give you explanation without admitting guilt at the moment? And I guess I can accept.
Well, sure, but let me clarify. You don't even admit guilt. Guilt is for crimes. This is not a crime. All you'd be doing is admitting responsibility. I mean, I know it just sounds like a matter of words to you, but you're not guilty of a traffic ticket because it's not a crime. It's only a civil infraction. You can't go to jail on it. All you can do is be fined on it. So what you do is admit responsibility, but you can give me your explanation. Go ahead.
If I was to have rolled that stop sign, and I appreciate your I know court can be a lot of wordplay, so I try to be real careful with how or what do they call it, lawyernese or whatever. But
legalese? You mean
legal?
The vocabulary?
Yeah, that's it.
Yeah, call that
legalese. That's funny. It was late at night, and I was coming to work. I came up to what I would assume was a complete stop. If it wasn't, because the officer gave me a ticket, obviously, but it was 11:30, 12 o'clock at night, downtown Saugatuck, where there wasn't anybody around at all. I just had to get down to work and clean up cans for the next morning. But I will pay the ticket then, and I appreciate you lowering the price for me as well, Your Honor. I know you didn't have to do that for me. Sorry, I'm trying to find what judge. What is your name, sir?
Dan Norbeck.
Norbeck? Thank you, Norbeck.
Yes, I'm the magistrate who's hearing this. Deputy Kaminsky is here on Zoom. I'm looking at him. He's the deputy.
Yep.
And you may want to give it a few minutes before you go to try to pay that at the window, because they don't know that I have reduced the fines and costs. They won't know it for a few minutes until I process the ticket.
Yes, sir. Thank you, sir. I appreciate it, sir. I'm just trying to work in town, and it's been just, the housing market's weird, and I appreciate you lowering my ticket for me.
All right, I'm going to go ahead and release you then. Thank you.
Thank you, sir. I hope you have a wonderful rest of your day.
You too.
Thank you, Kaminsky.
Well said, Deputy. Thank you.
Thank you, Your Honor.
All right, gentlemen, this is a citation issued on March 24th of this year on 58th Street there in Manlius Township. It is a speeding citation on an actual 55 and a 35. However, it was only written as a 1 to 5 over. Mr. Maru, you're here on this 1 to 5 over speeding citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation to court as to how or why this happened. Or 3, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
I believe the second option. Well, let me explain it a little bit, right?
Okay, yep. What is it you wish to tell me?
So technically, yes, I was speeding. Mr. Garcia pulled me over and I was doing 55 and a 35. I mean, he did a great job. Take nothing away from him. When he pulled me over, he informed me I was doing 55 and a 35. The only reason I'm fighting the ticket is, I mean, I was guilty of it, but I was taking a new route to work through Fenville. I usually take the highway, and I was unaware that I was in a 35. And then when he pulled me over, and we had this little discussion about it. He was very generous, and he says, if you were to slow down just a little bit, I would have let you go. I told him as well. I said, sir, I have no idea where I'm really at, and I was totally unaware I was speeding. So technically, I had no intention of slowing down at all due to that thought I was in a 55, which is why I'm trying and fighting this ticket a little bit.
Yeah. Well, the thing is nowhere does it go 55 to 35. There's always a 45 in between. So you missed 2 different signs, right?
Technically, yes, you are right. As I went through Fenville, turned on to, I think it was to Fenville, outside Fenville, going towards Holland. Yeah, you are correct, sir.
All right. So here's what I will tell you. Like I said, he wrote you the smallest speeding ticket he can write. Most of the time when people come here and they want to talk about tickets, what they're worried about getting is points on their license. Do you know what I mean by that?
Yes, sir.
Is that your concern?
No, I don't want to sound ridiculous on this. So when I was young, I was taught to fight tickets due to the benefit of me as a 50-50 chance that the officer might not show up. And if they do, it also provides them of 2 hours of overtime. So I kind of try to help him out and get me try to get me out of it.
Yeah. All right. Well, like I said, I don't think that's such a bad idea in terms of, exercising your right to show up, because you're right. There's lots of reasons why an officer might not be here. And if the officer's not here, the ticket goes away. So probably not a bad strategy. But you're all set for what we need to do here in court. The only thing the court does to you on a citation like this is that $100 fines and costs. So you need to call the district court and make arrangements to pay that fines and costs. But other than that, we're all set for what we need to do here today.
Okay, thank you.
All right, this is file 2500545SC. This is Griffin versus Bareski. We are here on this small claims case. What small claims means is that nobody is represented by an attorney. You're both here without a lawyer to see this resolved in front of me. It also means that no one is asking for a jury trial or anything of that nature, but this matter to be decided here in front of me. So first things first, if you're both willing and able to proceed in front of me, I'm going to swear you in. I cannot see you, but if you would raise your right hand, Mr. Griffin. And Mr. Barwick, if you could take yourself off mute just for me to make sure that I'm able to hear you.
There you go. Can you hear me?
Yes. Mr. First things first, well, I'll swear you both in. You swear or affirm that anything you would testify to here today would be the truth, the whole truth, and nothing but the truth?
Yes.
I swear.
All right. First things first, I do see on this affidavit a claim that it is listed as Jayco civil process, but they have you as Joel Bareski, ending in SKI. I'm not sure that's correct. I think your name is Joel Beverwick, right? As it appears on your, all right. So the correct spelling is Beverwyk, but you do work for Jayco, right? We have the right person?
That is correct. That is me, yes.
All right. So here's the first thing I need to explain to you, Mr. Griffin. You cannot sue what you're suing for in small claims. This is not an appropriate case in small claims. Small claims is only for you to sue for your out-of-pocket damages. So essentially what you have here is, I'm not really sure, but you are suing Mr. Beverwick in his capacity as a process server?
Yes, for abuse of process and impersonation of a police officer that led to a forceful winter eviction.
Okay, you cannot sue for that in small claims. So I'm not telling you you couldn't sue for that. I don't know, maybe you'd find a lawyer who would possibly take this for general civil, but it's not a small appropriate case for small claims. It would be dismissed without prejudice. We would not be able to proceed here on this today. You can't sue for these things. If you think a crime was committed, you have to report the crime. And these are not out-of-pocket expenses. There was, in fact, a lawful eviction notice. I think you were actually even arrested for a trespass at this property. I'm not sure why you're suing him, but he would not be able to arrest the woman in charge of the Watson trailer park. That you're just mixing and matching parts of this process. All he would do would be serve that eviction notice and that you were evicted that day. I'm not sure how that turned into a small claims, but what I'm telling you is it is not appropriate for small claims. You can't sue for that here. All right.
I was told in Allegan that general civil is small claims or large claims, and he showed up impersonating a police officer with weaponry and used threats and intimidation, and the expenses from the winter forceful eviction, even though there is a stay on the eviction processes during severe weather, it has cost me out of pocket.
Everything you're saying is incorrect. First of all, this happened in November. It was delayed at your request, but the eviction order was still signed during the fall. December 4th is the fall, and it's not the winter. Winter doesn't start till December 21st. If this person impersonated a law enforcement officer, that would be a crime, not a civil suit. And your damages are not out-of-pocket damages, sir. You're suing for damages, theoretical damages. And I can explain, just so you understand, the difference between small claims and general civil. Small claims is without an attorney, and you're very limited in the kind of things you can sue for. You can only sue for actual money that you lost as a result of these actions, but it cannot be theoretical, like, oh, I didn't get to go to work for 2 days. It has to be literally, I gave this person money and they didn't give it back, something along those lines. Now, in general civil, you can sue for all kind of stuff. You can sue for things like emotional affliction, intentional affliction of emotional distress, all kind of other things. But general civil generally involves attorneys. Otherwise, you may not be able to figure out how it works. Small claims is very simple on purpose so that people can do it without a lawyer. But because it is simple, you are limited in the types of things you can sue for. And the types of things you're suing for here are not things covered by small claims. So small claims is a small subset of civil law where you sue people. General civil is kind of all the rest of where you sue people. If you sue someone for below $25,000, you do it in district court. And if you sue them for more than $25,000, you do it in circuit court. But all I can explain to you is this is not the kind of case that would ever happen in small claims. I'm putting a lot of meat on the bone to sort of explain to you why it's happening. But this case would be dismissed, but it would be dismissed without prejudice, meaning you're free to file it in an appropriate venue somewhere else, some other type of court. You're not barred from pursuing this if you think you can pursue it, but you can't pursue it in small claims. Does that make sense?
Yes. With how it was explained to me, Allegan, they had me file it as small claims when I came to ask the protocol of how to try to sue this individual who showed up with weapons, who was not a police officer, and I mean, the damage is severe to me personally, mentally, and possession-wise.
Well, sir, all this person did was serve you with notice. You were evicted by a court. It was a court order to evict you. It is not this person's personal decision to evict you. He's performing his job.
He showed up and got the officers to forcefully arrest me, And
Yes,
from my
sir, because you
understanding,
resisted arrest. I read the affidavit. I'm actually the magistrate who charged you with 3 counts of R&O, you and the other gentleman. I'm very familiar with what happened. That is not something you would sue this person for.
even though they're a process server who was impersonating a police officer.
Well,
there were apparently real police officers there. Don't you think if he was impersonating a police officer, the real police officers would have taken offense to that and arrested him?
You can say that. I haven't heard any evidence for, nor do I suspect that that's the case. But you know, you'd have to make that case. But how that would lead to damages when you were evicted by a court and you're suing the process server, sir, that doesn't make a lot of sense. But I won't tell you how to live your life. You maybe want to talk to a lawyer about how you could make this work. But I will tell you that at the window, the clerks there are not allowed to tell you legal advice like, oh, you should sue here and not here. They can't do that. So you have to get all the way to me before I would explain why this isn't for small claims. But I don't know what else to tell you other than we're sort of done here with how far this case could go in front of me, okay? I'm gonna go ahead and release parties. Thank you.
Thank you.
Oh, that was so much fun. A week of Norbeck. Oh, we don't go by the Insomniac crew for nothing on Discord. We have the Insomniac chat. Because most of us are. And thank you so much for the compliments, Kelly Hughes. I'm glad you enjoyed the videos. I'm so happy that you're here. I'm so happy all of you guys are here. That was a fun one. God bless Texas. Oh. I had Texas on last night, Mortimer Duke. I started off with Sugarland. This was all Michigan tonight. I really like Judge Norbeck. He's funny and he gets some of the most outrageous circumstances. That's me. That's what was going on last night. My insomnia and my narcolepsy kind of hit me all at once, and I didn't eat all day, so then you add in my diabetes, and I hadn't slept using my BiPAP for 2 nights. So, yeah, I slept halfway through the stream. I think that's Mortimer Duke's point. Oh, I'm not gonna lie, it's tricky. Even I struggle with it on the regular. I feel like it's intended for people above my IQ grade. No, it's really made for gamers, by gamers. That's what it originally started out for, was for people to game together and be able to communicate while they were gaming. I'm not a gamer, but it did kind of morph into a chat hub where people could just be on voice calls and video calls together, and it's kind of like Zoom for the average person. But when you get into, there's so many channels and how it's set up. I mean, it's a lot. It's a lot to learn. I know Auntie M and Sir Philip, they literally spent weeks putting it together, hours every day building it. And they did a wonderful job. They absolutely did. Oh, I love you, Nana Laura. Yeah, you're going to have that. You're going to have that. Discord for president. I do like going in there and in Ava's place and in Billy's game room, and there's Earl's got his own little game room. There's you can play one-on-one games with people, or just play by yourself. So every once in a while, I'll go in there and play some of the word games that they have, because they're kind of neat little word games. And, you know, I'm nutty like that. Yeah, it takes a minute to learn it, but once you get it down, you know, I still don't have it down, but I've got enough of it down that I can, you know, I can have personal chats, and I can, you know, play the mini games, and I can do the basics, you know. I'm a basic kind of gal. Oh my gosh. So I don't know. Some of you might have heard me complaining about it, but my mouse, it kind of, it's hit the ground a few too many times. The cats have sat on it a bit much. This was a present from Jenny Green over a year ago. It was while I was still streaming in the basement. Yeah, y'all remember that. It has been giving me problems lately, where when I try to scroll, if I go down, the screen goes up. You know, it jumps all over the place. So that right there is my new mouse. I had to order a replacement. The original programming code, C++. I don't know how to code in C++, but I do know of C++. Thank you. Thank you, thank you, thank you. It did just arrive, but I do appreciate that very, very much. I like it because it's a silent mouse. It's as silent as it's gonna get. You know, when I used to use my laptops, when I streamed using my laptops, I had just the touchpad, and you could hear every click every time I clicked off or on or whatever. Oh my goodness. It was annoying. I'm surprised people stayed with me. You guys have grown with me literally from the start. Like, some of you guys have been here from day one. Sir Philip. A T minus in C++. No, but they sure are cute. I remember putting one of them in a video. He made his debut. And then before you found out that he was a protected species, you'd already fed him to the chooks. Are they still classified as a protected species there? The field mouse, I think it was. You'll figure it out. Yep, the tiny little Malay field mouse. Yeah, that was I remember when Sir Philip found out that they were a protective species. Yes, Steve the mouse. Oh, it was the bushy-tailed Mallee mouse. Steve was such a cutie. All right, guys. I'm gonna call it a night. I can't thank you guys enough for being here, for being a part of my little world. You guys are so great to me. You make me laugh, you make me smile, and keep me going. That's for sure. You keep me going. Oh man, that means I gotta do stuff. Oh, just a heads up, guys. Thursday will be my day off. For sure. Possibly Friday. My daughter is coming home, so I have to make a trip to Madison. I was not given an option. It's non-negotiable. And yeah. And then her father and I get to haul her back here. I love you, Charlie. That's kind of the rule around here. I will. She hates that I talk about her. Her schoolmates have found out that her mom's a YouTuber. They all apparently like subscribed. They don't watch the videos, but they did subscribe to support the channel. So I definitely appreciate them. You know what? Unfortunately, TikTok got to her before the colleges did. But I did have some influence on her because she's not entirely psycho. Yes, and remember, be kind. Kindness is key. Yep, we now have a fluffy billy butt. Hey now, hey now. No, she's nothing like me. Nothing at all. Nope, nothing. I can't take any credit for her. Everybody's like, you should be so proud. You did so well. No, I didn't. She is her own kid. She definitely she's made choices and stuck to them, and they've all been good choices. So she's nothing like her mom. It's something. It's something, all right. Thank you guys for coming out tonight and spending this time with me. I can't tell you how much I appreciate you. Be safe, be well, sleep sweet, and much love.